Good morning and welcome to the Berks County Board of Elections meeting. Today is September the 25th. It is 11:15 and we will call the meeting to order. The meeting did start a little bit later today because our board meeting, which starts at 10, ran a little over. So I apologize for any delay in getting this meeting started. So moving along, we will read the public comment notice and I will ask Stephanie to please read the notice.
Public comment will be accepted in person and through the Q&A function. Please include your first name, last name, and municipality for all comments. Any comments without name and municipality will not be considered. Each citizen can submit one comment. Comment length is dictated by limitations of the platform being used, Teams Q&A. In-person comments will be accepted first, followed by comments submitted virtually. The meeting comment period is limited to a total of 30 minutes, including both in-person and virtual comments. This time period may be extended at the county's discretion. Please be concise. Comments that are germane to county business will be read during the meeting and should not be considered to be interactive dialogue. The county shall be the final arbiter of whether a comment is germane and should be read. Any response to public comment will be done at the county's discretion.
Okay, thank you very much, Stephanie. Move on to a public comment. Do we have any public comment on agenda items? We have one here in person. It is not on an agenda item, nothing online either. We'll move to the approval of the minutes from the September 4th election board meeting. Are there any additions or corrections for the minutes? If none, the minutes stand approved as presented. There are 3 items on the agenda today. The first is the logic and accuracy testing update. And Ann will discuss the plans for the upcoming LNA testing of the DS 200 precinct tabulators, the express vote ballot marking devices, the poll books, and the high-speed scanners for the 2025 municipal election. Yeah.
Okay, good morning. Just so you know, just a reminder, the logic and accuracy testing, or the LNA testing that we do, these are steps we take before each election just to ensure that ballots, scanners, ballot marking devices, and all the components of our voting system are properly configured and they're good working order before the election. So we're going to begin with that on Monday at our South Campus, and our technicians will begin the LNA, or logic and accuracy testing, of the ballot marking devices and the precinct scanners. And again, that's going to be Monday, September 29th. That's going to begin at 9 a.m. at our South Campus, and it'll continue through the week as necessary. Friday, October 24th, we're going to test our central scan tabulators, the DS 450 and the DS 850. These are our high-speed scanners. This test will take place at a new location. Actually, we're housed at 600 Penn Street on the 3rd floor, and that will begin at 10 a.m. again on October 24th. Monday, October 27th, we'll begin the logic and accuracy testing on the poll books, the electronic poll books. That also takes place at the South Campus. It will begin on that Monday at 9 a.m. The public is invited to observe. We will also send notices out to the parties today, and we will post this information on our website. We just ask that any observers contact our office ahead of time so we can make arrangements for them to be there. And like I said, it will be posted on our website, the Election Services website, after this meeting today.
Okay. Thank you very much. Any questions for Ann on item number 1? Okay. Item number 2, update on the Preserving and Protecting the Integrity of American Elections Executive Order regarding the amending of the voluntary voting system guidelines. And Cody did have an update at the last election board meeting. He has a little bit of an update today, but not much going on there yet. But Cody.
Thank you, Commissioner, and good morning, Election Board. That is correct. In follow-up to my update at our previous election board meeting, if you recall, there were revisions potentially pending to the voluntary voting system guidelines in the Technical Guidelines Committee of the Election Assistance Commission. The Technical Guidelines Committee met on September 17th to further discuss those revisions. Included within those revisions, as you will recall, was amended language regarding barcodes in response to the executive order. Originally, on the agenda for the September 17th meeting of the Technical Guidelines Development Committee. There was originally a vote on the revisions and recommendations to the voluntary voting system guidelines. However, in the beginning of the meeting, there is a motion made to remove that vote from the agenda as further discussion was deemed needed on the revisions as a whole. That motion carried.
And that was a motion to table, right?
Correct, yes. Essentially where things stand regarding potential revisions to the voluntary voting system guidelines is discussions will continue in the technical committee. It's something that we will continue to follow for any developments. I would note, though, that even if there was a vote by the guidelines committee to make recommendations or revisions to the voluntary voting system guidelines, that would still then send it to the Election Assistance Commission, and then they would have their own separate process to review the recommendations and revisions, and then there would be a lengthy period before any such revisions would be implemented. So long story short, no substantive updates that affect our ability to use our current voting systems.
Okay.
Quick question, if I may. The committee that makes that table, who sits on that committee? Who do you know?
As I understand it, the committee is established through HAVA, but essentially it's interested parties that are appointed. Like I know there's some, I believe, like folks like election director type roles throughout the country, and there are I believe other appointees from various commissions, I believe, but I don't know specifically who sits on it off the top of my head.
Thank you.
Okay, thank you, Cody. Now move to item number 3, an update on the Pugh versus Berks County Board of Elections litigation filed in the United States District Court for the Eastern District of Pennsylvania and subsequently appealed to the United States Courts of Appeals for the Third Circuit. Our solicitor will give an update on that as well.
Thank you, Commissioner. If you will recall, when we were accumulating votes for the May primary election, there's a candidate by the name of Brandon Pugh who pursued a write-in candidacy for the mayor of Lyonsboro. Mr. Pugh filed a petition to accumulate 5 Republican votes. Along with that petition, Mr. Pugh also submitted a supplemental petition asking to be declared the winner of that race, despite not receiving the statutorily required minimum of 10 votes for that office. If you will recall, 25 PS 3155 states that in the primary, the county board shall not certify write-in votes unless the total number of votes cast for said person is equal to the number of signatures required on a nomination petition for that particular office. The supplemental petition that was filed along with the petition to accumulate alleged that if the board were to apply these requirements, it would be a violation of Mr. Pugh's constitutional rights. At the June 6th meeting, the board voted to allow Mr. Pugh to accumulate those write-in votes, but declined the relief requested in the supplemental petition, as 3155 is good law in Pennsylvania. And there were previous constitutional challenges to 3155, although a little bit different, but its constitutionality was previously upheld. After that occurred, on June 26th of 2025, Mr. Pugh filed suit against the board in the Eastern District of Pennsylvania, alleging that because he was not declared the winner, that this board violated Mr. Pugh's constitutional rights in that regard. Generally, as the board knows, we don't comment on ongoing litigation, but I think it's important to provide an update to the board in this regard, and also all of the information that we're sharing is public record. So Mr. Pugh, again, filed a complaint on June 26th. In response to that, the county filed a motion to dismiss that complaint. The county is represented in this matter by Jeff Bukowski, our special counsel to the Board of Elections. And before I go further, I just again want to thank Jeff for all of his work on this matter to date. I think it should be noted that he was under some very tight response deadlines set by the court. And as always, he met those deadlines and, has just done a great job for us so far. So in response to the complaint that was filed, Jeff filed a motion to dismiss the complaint in the Eastern District. That was subsequently granted by Judge Gallagher, so the case was dismissed. Mr. Pugh then appealed that decision to the Third Circuit Court of Appeals, and along with that appeal also filed essentially a motion for injunctive relief, which sought an injunction to place Mr. Pugh on the ballot during the pendency of the appeal. The motion for injunctive relief was denied by the Third Circuit. And within the response that we filed to the motion for injunctive relief, Jeff also included a motion on our behalf to summarily affirm the Eastern District's decision. So I have asked Jeff to be present here today, and I will turn it over to him and just ask if he can just kind of provide a brief overview of where things stand in the Third Circuit and if anything I may have missed on my end. And again, just want to send my thanks to Jeff for all of his great work on this matter.
Thanks, Cody, and good morning, members of the board.
Good morning.
Just to follow up on Cody's comments briefly, I think he very thoroughly summarized it, where things stand. The question at the district court level and now on appeal to the Third Circuit was really whether or not this statutory section that sets a minimum number of votes in a primary is constitutional. At the district court level, we fought the issue of what standard applies to this. We argue that a balancing test under cases and what's called an Anderson-Burdick test applies. The plaintiff argued strict scrutiny should apply because his First Amendment and 14th Amendment rights were being violated. We prevailed in that argument at the district court, and the district court, applying that correct standard, ruled that the section 1405, Cody referred to it as section 3155, that's the PA statute section, the codified section. But this requirement is constitutional because for two reasons. The minimum vote requirement imposes only a minimal burden on Mr. Pugh and other candidates. And then secondly, the state's interest in requiring a minimal amount of support to get placed, to be called the winner in a primary is satisfies that minimal standard. So we prevailed there. September 3rd, the district court entered its order dismissing the complaint. On September 8th, Mr. Pugh filed his appeal. A few days later, September 11th, he filed his injunction motion at the Third Circuit. Cody explained that we wanted to try and get this resolved as quickly and at the least cost to the county as possible. So we found a rule that allowed us to move for summary affirmance, which we did in our response. And Mr. Pugh was given, we filed that, we had a day essentially to respond to the injunction motion. And then he had a day to respond to our motion for summary affirmance. And on Monday, September 15th, the Third Circuit denied his injunction motion in a text-only order and further ordered that our motion to summarily affirm is still under consideration and a separate order will be issued on that motion. I think that bodes well for us. I'm cautiously optimistic that that means we will get an order summarily affirming the district court's order. It would have been easy for the Third Circuit to simply deny that motion and order that the parties file their merits briefs and go through the typical appeal process. So I'm cautiously optimistic that before the election, we'll get an order summarily affirming, but of course that remains to be seen.
Thank you, Jeff. Commissioner Linebaugh.
Yeah, just two quick thoughts. One, Some people might look at this and say, why in the world would the county go through this kind of cost for a person to get on a ballot for mayor of Topton? And the answer is the law is the law. The law is really clear on this. This is not one of those things where it's not like the undated ballot issue. It's clear. And if we start making an exception, say, you know what, this is going to cost too much money, we're not going to fight it, go ahead, let him on, then that's the slippery slope. What are you going to ignore next? I cannot emphasize enough the commitment of this board and this county to the letter of the law. That's what we follow. We look at case law. The case law backs up the law the way it's written. I'm not sure what's behind the effort to spend the kind of money the gentleman must be spending on his end, but that's not my problem. Our issue is to be responsible with the enforcement of the law. So I want to thank Cody. I want to thank Jeff Bukowski for their work. I just think it's a shame that we have to spend this kind of money for something that is blatantly obvious.
Chairman, real quick, just to follow up on that, and maybe this, Jeff, if you can answer this, if this case was allowed to be, if he was allowed, it was ruled unconstitutional that he needed to get these number of signatures, wouldn't that throw the process in chaos as far as, so anybody that runs for commissioner needs a certain number of signatures, anybody that runs for the state legislature, et cetera, et cetera. Wouldn't that set a precedent that everybody could say, well, this is unconstitutional, and the system would pretty much be in chaos?
I think that's right, somewhat, because what we really have, you have two ways to get on the ballot. A nominating petition, as you all know, and you gather signatures, and you have to get a certain number of signatures. And if you don't do that, you can wage a write-in campaign, as Mr. Pugh did, but the statute says to be certified the winner, you have to have the minimum number of votes as the same number of votes that you would have to have as on your nomination petition for that office. In this instance, it was 10. He got 5 votes in a 1 precinct borough. He got 5 votes, and he did have the most of any write-in candidate, but he didn't reach the minimum of 10, and the statute was clear. So if he were to succeed on this, every race across the county would have this issue of accumulating write-in votes and having election services have to declare, certify those votes and declare winners to candidates who failed to meet the statutory minimum number of votes. I'm sure the county would make adjustments to its process and be able to do it, but it would cause a lot more work, and I think chaos is a good word, Commissioner.
Thank you,
Yeah.
Jeff. That's all I have.
Yeah, thank you, Jeff. I believe part of the reasoning for that is you need the signatures to say there's enough support out there in the community for you to run for office. So I believe it's the same thing to say, if you're doing the write-in campaign, you need that same minimum amount of support from the community to be elected in that fashion as well. So I agree that it's something, this is the law, and we need to make sure that the law is followed.
Just one more comment, if I may, Commissioner Rivera, which is,
Yep.
Mr. Pugh is able to wage a write-in campaign in the general election.
Right.
He's not precluded. This decision only denied his certification as the Republican Party primary winner to get on the ballot in November. If he wages a write-in campaign and he gets the most number of votes, regardless of the number, the minimum number requirement does not apply in the general election. And the candidate that has the plurality in that election will be declared and certified the winner for that race.
Okay, thank you, Jeff. Okay, we'll now move to the election director's report. Yeah.
A couple of updates. We did finalize our ballot. We have sample ballots posted on the Election Services website. Can also announce that we can begin over-the-counter voting in the Election Services Office Monday, the 29th of September. Again, we'll have notification on our website for anyone interested in voting that way. Again, that would be available Monday through Friday between the hours of 8 and 5. And lastly, I can let you know that we sent our first batch of data voters to receive mail-in or absentee ballots to the printer this week. There was 20,000 voters in this batch. We're expecting the printer to begin mailing those ballots out, hopefully by mid to late next week.
Great.
Okay, thank you, Ann. And just want to clarify, when Ann says over the counter, this is you come in, you complete a mail-in ballot request form. If you're going to do it, if you want to do the over-the-counter voting, do not request a mail-in ballot form. You need to request it when you come in. You will get the paper ballot that you get for the mail-in. You complete it, you put it in the envelopes, and you turn it back in. In Pennsylvania, it does not have early voting, so you will not come in and vote on a machine. It's simply over the counter where you're getting your mail-in ballot there, you're completing it there, and you're handing it back in its envelope just like you would if you would request it by mail, receive it at your home, complete it, and mail it back. And so
There's one exception, that is you have to submit legal photo ID. And that's because they're processing the
right there.
application right there in front of you. They need something. You don't have that, you're not going to be able to vote right then.
So
It takes a longer, the
Yeah.
process will take longer if you don't have the ID.
Right.
Yep. So make sure, again, if you're going to do the over the counter ballot, don't request a mail-in ballot because then that needs to be dealt with as well before you're able to vote that day. Other thing also is 2 other points I want to point out is we're still looking for poll workers and interpreters. So if you know of anyone or are willing to work, please reach out to the Election Services Office and they'll be more than willing to share the information with you as to what you have to do. There's training that's provided. So become part of the process in elections, very important. And one item that we've mentioned in prior meetings, but we did touch on this meeting because there has been no change, is the dated or incorrectly dated ballots. In this election, although they will be counted, we will still continue to segregate those ballots because there are still pending court cases out there. So until it's finally resolved, we don't know when that will be. We will continue to segregate those ballots in case something would change right before the election or right after the election, that we would need to go in a different direction than what it is right now.
Yeah.
So
So
just wanted to bring
the
that as well.
advice is put in the date, the
Put in
date
the
you
correct
sign it.
date. Yep. As of now, if you don't put it in or you dated incorrectly, it will be counted. But that again could change at any time based on still two court cases. Correct, Cody?
right? Federal and state.
Yeah, so there's at the state level, the Baxter case is still pending. We do expect a decision soon. However, I'm not sure the court, because we're this close to the election, they may wait till hopefully after certification. But then also in the Third Circuit, if you remember, the Third Circuit affirmed the Western District's decision. There was recently, though, a petition filed for a rehearing en banc in that matter. So the original Third Circuit decision, which affirmed the Western District's decision, was made by a panel of 3 judges. So there's a recent request for the Third Circuit, all of the judges, to rehear that case. That issue about the rehearing en banc is currently being briefed. So that is still pending out there as well.
Okay. Thank you, Cody. Any other general comments from the board regarding current election-related issues? Okay, we'll move on to public comments. We have one in person. Do we have any online? None online. So Jeff, if you want to state your full name, municipality, and you'll have 3 minutes.
Good morning. My name is Jeffrey Wolf, Brecknock Township. In tight political races, voter mistrust and suspicion over election results is predictable. 2 online articles reveal fears of election vote tally manipulation in the 24 general election for president and U.S. senators. One theory suggests that the 265 Starlink direct-to-cell satellites launched days before the election could have been a, quote, backdoor into the voter tabulation machines, close quote. This, of course, could have manipulated the vote for Elon Musk's friend and associate, Donald Trump. In an election-related case now in the New York State Supreme Court, the plaintiffs in multiple districts allege that, quote, hundreds of voters chose the Democrat candidate Gillibrand for Senate and that none voted for Kamala Harris for president. The ES&S machines were used, by the way, in that particular case. Given that machine ballot marking and tabulation are standard for managing elections in Berks County, I make these recommendations to reduce that skepticism. The election code reads in part, the County Board of Elections shall conduct a statistical recount of a random sample of ballots. A random sample, in my opinion, should be conducted in a similar manner as the election board determines the ballot position of candidates running for office in a primary. Numbered balls pulled out of a bag by each candidate, the candidate with the lowest number being the top position and so forth. The procedure to select the precincts for the 2% audit should mimic the ballot position procedure by requiring partisan auditors to randomly select the precincts using a lottery. 202 choices must be available. The election board should then present the select ballot boxes with dispatch. And my second recommendation would be opening ballot boxes upon petition of electors alleging fraud or error. In part 3261 quotes, it should not be necessary for petitioners to specify in their petition, the particular act of fraud or error and so forth. And they do not need to offer evidence to substantiate the allegations of the petition. Close quote. If this level of scrutiny was standard procedure in the post-election audit, that would be the 2%, and possibly the fraud or error audit, and the results were unremarkable, I think a greater degree of confidence in the electoral outcomes most likely would occur. That's it. Thank you.
Okay. Thank you, Jeff. Just a few comments. One, Ann spoke about the logic and accuracy testing. That's one of the ways the machines are tested to make sure that they are actually reading what the ballots are. There's a deck of test ballots that is run, and they compare what the test ballot, the test deck is to what the results were that were run from the machines. They're not connected to the internet in any way, shape, or form. That's one way of knowing that the machines are counting the ballots the way they're entered, and that is done by a third party. The other thing is there are 2 audits done there's 2 that could be done. One is the 2% audit. The other is the risk limiting audit that is done random samples. And both of them are done by hand count. And we invite both members of the Republican and Democratic Party to participate in those hand recounts for those audits. So there are, it's random.
Yep.
We select them randomly. I mean, there's really
Yeah.
no science to it. We kind of just,
We look at numbers.
we're trying to get it within that 2%, or
Mhm.
close to that 2%. That's
Yeah.
all.
Yeah, so there are things in place to avoid situations in our election. So I'm certain here in Berks County that the elections does a good job in making sure that those audits are done randomly, the 2%, and the state is the one who gives us the risk limiting audit. So any other comments from the board? Okay. No comments online. I will accept the motion to adjourn.
So moved.
Second.
Thank you very much. The meeting is adjourned.